United States versus United States versus United States of America. Few Americans realize that there are three definitions for the United States. Most have been misled to believe that the term United States has a single meaning and is a generic term referring to the country as a whole. This is not always so. The legal standing of each individual American, to any one of the three, varies depending on his status or lack of status in law. If you are a citizen of the District of Columbia, the democracy, you have privileges granted by Congress. If you are a citizen of the Union, the Republic, you are endowed with the unalienable rights mentioned in the Declaration of Independence. All licenses are privileges, whereas rights are gifts from God. Black's Law Dictionary, 4th edition. United States. This term has several meanings. 1. It may merely be the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. 2. It may designate territory over which sovereignty of the United States extends, or 3. It may be the collective name of the states which are united by and under the Constitution. Hooven and Allison Co. vs. Evatt, 65s Court. 870, 880, 324 U.S. 652, 89 L. ed. 1252. The first one, United States, is as a sovereign among the nations of the world under international law, a nation amongst nations. It consists of 1. The Union States and 2. The Federal Zone, District of Columbia, U.S. territories and possessions, forts, magazines, arsenals, dockyards, and other needful buildings, and is represented collectively in the international arena by the U.S. consuls abroad as one and the same entity. The flag that properly represents it in the world arena is Old Glory. The second, 2. United States in Hooven, Supra, was created by the Constitution in Art. I, Section 8, Clauses 17 and 18. This second, United States, received further authority when under Art. IV, Section 3, Clause 1 and 2, to dispose of and make all needful rules and regulations respecting the territory or other property belonging to this United States, but it gave no authority to Congress to extend its municipal authority into the Union States. The latter gave Congress power to extend its jurisdiction, law-making powers, beyond the limits of the District of Columbia over which Congress was to exercise exclusive legislation to include the former territories such as the Northwest Territory, Alaska, Hawaii, and the Philippine Islands, and currently, American Samoa, Guam, Puerto Rico, the Virgin Islands, the Northern Mariana Islands, and other territories, possessions, areas and enclaves. Its flag is the Stars and Stripes with the yellow fringe representing a plenary martial law jurisdiction. The geographical area known as the United States (D.C.) has its own citizens, United States vs. Cruikshank, 92 U.S. 588, who are generally referred to as United States citizens. The yellow fringed flag signifying this jurisdiction is not for decorative purposes. It signifies the jurisdiction of the district, also known as the corporate U.S. federal, that has been extended into the Union States by the 14th Amendment. This is the flag of the democracy. It should be obvious to everyone who observes the flag next to his senator or representative from Washington, D.C. that he represents the district's interest in the area of his constituency and not the other way around. When the function of the circuit courts of the United States of America was changed to appellate status by another layer of courts, these courts were labeled United States District Courts, the courts of the district. Where are the courts of the United States America sitting today? They do not exist. The third United States of America described in Hooven, Supra, are the 50 Union States united by and under the Constitution. This third United States of America is known as the Republic. Its flag is Old Glory. In the constitutional courts, the civil authority of the Constitution is signified by the stars and stripes hung vertically behind the bench, just as it hangs behind the Speaker's chair in the House of Representatives. Why, one might logically ask, is such a flag not found in our courtrooms today? Because they are not constitutional. The Republic has citizens of its own called American nationals. Those are the sovereign citizens who qualify as such by being members of the posterity referred to in the preamble and can only be the natural-born or naturalized white inhabitants of each state whose forefathers delegated by solemn agreement certain powers to the Congress of the United States D.C., which powers are limited to those delegated in Art. I, Section 8, Clauses 1 to 16 in Art. IV, Section 3, Clause 2. Though today unlawfully expanded far beyond constitutional limits by 1. Usurpation, and 2. Deception of benefits by contract, which American nationals unwittingly and unknowingly enter on the other hand. When legislating for the third United States of America, all powers not enumerated in Art. 1 Section 8, Clauses 1 to 16, are reserved for those sovereign states, and the citizens of those republics, by the 9th and 10th Amendments to the Constitution of these United States of America, in Union. The founding citizens of the Republic gave very limited powers to the Congress of the United States to legislate for the geographical area known above as the 3 Union States, described in the Hooven case, supra. These legislative powers are limited to being exclusive within the area of its jurisdiction, as is that power possessed by any one of the legislatures of the 50 states of the Union when legislating for its responsive geographical area. However, when legislating for the 50 Union states collectively as a nation, Congress is bound by the chains of the Constitution and must remain inside the jurisdictional boundaries of Art. 1 Clause 8, CLs. 1 to 16, and out of the jurisdiction of any particular state, 18 U.S.C. Clause 7, 1, 5, and 7, see particularly Clause 7, 3. Constitutional law. Territories, power of the United States over, as plenary, full, entire, complete, absolute, in exercising its constitutional power to make all needful regulations respecting the territory belonging to the second United States. Congress is not subject to the same constitutional limitations as when it is legislating for the third states of the Union. Hooven and Allison Co. versus Evatt, supra, Downs versus Bidwell 182 U.S. 244. Constitutional guarantees as extended to territories. In general, the guarantees of the Constitution, save as they are limitations upon the exercise of excessive legislative power, when exerted for or over the insular possessions of the United States, extend to them only as Congress, in the exercise of its legislative power over territories belonging to the United States, has made those guarantees applicable. Hooven and Allison Co. versus Evatt, supra. I.e., the court states that the rights of those within Congress's sphere at exclusive jurisdiction are mere privileges extended them at the whim of Congress. Those who live in the District of Columbia, its enclaves, territories, or possessions, and those who live in the ceded areas of the several states called federal areas or enclaves are known as Number 2 United States citizens. They are true federal citizens. From the standpoint of constitutional law, Congress has 100% control over the lives of all Number 2 United States citizens whenever they reside in the several states, or elsewhere, and their rights are subject to Congress's exclusive legislative authority. Such rights are called civil rights. This type of government is a legislative democracy, the object of which, since passage of the 14th Amendment, has been to rob natural-born citizens of their birthright and bring all Americans into the democracy under the legislative authority of Congress as a single group under authoritarian rule, contrary to the intent of the organic Constitution. In contrast, white people living in the Union States, the Republic, are not under the Congress's legislative authority and are known as American nationals. They are citizens of the Third United States of America. The reason that the federal government prefers that everyone submit to its authority, voluntary, under the 14th Amendment through participation in Social Security is that the IRS can lawfully tax only federal Number 2 United States citizens, its employees and those others who willingly contract with it, and not Number 3 American nationals who chose not to. Its authority does not lawfully extend to the latter unless they voluntarily place themselves under the private commercial law of corporate U.S. federal by contracting with it by such a simple and subtle means as merely using Federal Reserve notes and associated commercial paper instruments. Included in this latter group are those whites who elected to be 14th Amendment citizens by voluntarily entering into unilateral contracts with the federal government by contracting for Social Security old age insurance, obtaining licenses, privileges, etc., and by voluntarily making W-4 and 1040 contracts annually. This is what is meant by their claim that the federal income tax is voluntary. In this way, those who volunteer themselves into federal contracts place themselves under the authority of Congress's powers to regulate commerce under Art. 1, Clause 8, CL.3, subjecting themselves to the federal income tax. Thus the federal government ultimately obtains legal title to all of our property and total control over our lives, leaving us with only the equitable interest so long as we perform the terms of our contracts. A serious breach of the contract means the loss of our equity, i.e., the government will take our property. The first clause of the 14th Amendment created a subject matter enclave jurisdiction to artificially create citizens not circumscribed by the organic law, Negroes, corporations, licensees, etc., and placed them directly under municipal authority of Congress so that wherever they might reside, in any one of the several states, territories, or possessions, they are within the scope of Congress's legislative authority as their existence as a federal state-created privilege. Since the nation's bankruptcy in 1933, and the subsequent overthrow of the Constitution in 1933, though our government will not openly and officially admit its position is that all natural-born citizens are also subjects with jurisdiction acquired by our voluntary contractual participation in worldwide social insurance. Accordingly, all races are considered joined together as 14th Amendment DC citizens, subjects since being enrolled into commerce by their birth certificate, and by subsequently confirming their consent, when applying for such unilateral contracts as the driver's and marriage licenses, Social Security application, selective service and voters registration, bank accounts, credit applications, W-4, and 1040 income tax contracts, etc. For those who would choose to follow Satan, God provided flaws in the Constitution, Art. 1 Clause 8, CLs 3, 17, and 18, and Art. 1 Clause 10, CL. 1 for the international bankers to discover, to humble Christian Americans who would turn their backs on their God to worship the strange gods of greed, power, prestige, sex, the sports world, etc. Their idols of materialism, all violations of the First Commandment. When a natural-born citizen with a SS# refuses to sign a 1040 contract, the federal courts will rule that he has a no legal duty, which compels him to contract with government without ever requiring the government to produce the laws that make him liable for the tax and require the affirmative act of filing. Such quasi-coerced and compelled commercial agreements, though entered out of fear, need only be entered voluntarily and intentionally to have validity. The fact that he did not enter the agreement knowingly is immaterial. Ignorance of the law is no excuse. It has taken concerned American nationals 62 years to figure out why our constitutional protections have been legislated away since 1913 by a Congress initially ordained with no such powers. Under the common law, violations require an injured party, a corpus delicti, and contracts must be entered knowingly, willingly, and with full knowledge of informed consent, intentionally. Having done so unknowingly or unwillingly could not have resulted in any forfeiture of unalienable rights that would bring about a loss of property, labor, or liberty held in captivity, as has been the case resulting from alleged Internal Revenue Code violations by American nationals. Such an insidious plot perpetrated against American nationals could only have been conceived and hatched in the mind of Satan. How did this system of commercial law develop? It developed as a result of the use of the introduction and use of Federal Reserve notes, commercial paper. In pursuance of our use of this commercial paper, the courts in our country are proceeding under the old Negotiable Instruments Law, which has been codified into the Uniform Commercial Code and subsequently adopted by all the states. A Federal Reserve note dollar is a fictional instrument, a colorable dollar, and not the lawful dollar described in Clause 9 of the Coinage Act of 1792, 371-1/4 grains of .999 silver. Common law and equity use gold and silver, admiralty use gold only. All systems of law described in the Constitution are based on substance. No system of law that uses paper can be genuine, therefore it is a colorable system of law. So the banksters and the Bar Association invented this new colorable jurisdiction to support this colorable law called statutory law, which operates not according to public law, but according to public policy. For many years patriots thought that because this statutory jurisdiction followed admiralty rules it was an admiralty jurisdiction. Not so. The only reason the banksters did not enforce the bankruptcy of 1933 by 1938 and foreclose on this and other bankrupt nations is that they did not have control of the guns. So you see why it is today that gun control is our government's paramount objective through deception of anti-terrorism legislation? Our servants of the public trust have long ignored the meaning of the 9th and 10th Amendments and the concept of unalienable rights, so eruditely stated by Jefferson in the Declaration of Independence for the benefit of the people of this nation and their posterity. Our natural and unalienable rights run much deeper than those so-called civil rights regulated by Congress through the 14th Amendment. Proof of this, among others, is the duplicate due process clause provided therein for its citizen subjects. If we expect to claim our rights, it is our individual responsibility to see that the Bill of Rights is enforced and that those violating our rights are tried for treason. Truly, we are engaged in a spiritual battle. The situation that presently exists in the 50 Union states is the very reason the Second Amendment was written, so that the contract called the Constitution could be enforced by the people, i.e. the state three citizens. Why all the confusion over the simple term, United States? Obviously, to extend the taxing powers beyond their constitutionally authorized limits. Everybody knows that. The District of Columbia is not a state within meaning of the Constitution, U.S. versus Virginia 1805, like the 50 states of the Union, and yet it is referred to in all the two United States codes as a state, meaning the corporate and statutory venue of the Union. The District of Columbia is a corporation which is also known as the 1 and 2 United States. It must have its own definition for state, since it 1 and 2 and the territorial states were not formed as Union States 3 by and under the Constitution. It is the primary entity owning Guam, the Commonwealth of Puerto Rico, American Samoa, the Northern Mariana Islands, the Virgin Islands, etc., which are federal states. Nevertheless, the federal courts are unconstitutionally enforcing the jurisdiction of corporate U.S. federal 2 entity upon the entire geographical area of the Union States 3, as if they were under Congress's exclusive legislative authority. See 18 U.S.C. Clause 3231, with its cross-references referring the reader to 18 U.S.C. Clause 7, at 3. The law is clear on this point, but the courts won't enforce it. Here are the facts concerning the term United States when used in the Federal Tax Code, Title 26, which has its own peculiar definitions, called terms of art, written by the craftiest of legal minds, and paid by our tax dollars to defraud us, the American people, of our labor property. 1. United States does not mean the 50 states of the Union except in 2 extremely limited areas which deal with excise taxes on articles and goods. 2. United States means federal areas within the 50 states of the Union which are ceded to the United States and under the municipal authority of the Congress seated in Washington, D.C., but it does not include the entire geographical areas of the several states of the Union. 3. United States means the possessions of the District of Columbia, which are its states Guam, Puerto Rico, American Samoa, and the Virgin Islands. It does not mean the 50 Union states. 4. The numbers 2 and 3 above are called states but are not to be confused with the states of the Union, such as Ohio, Indiana, and Kentucky. The Internal Revenue Code is purposely written to mislead and is purposefully misconstrued by the courts in the interest of promoting public policy. 5. United States are Congress assembled at home, the seat of government, the District of Columbia and its territories termed states in the IRS Code, and its possessions, ceded areas, military posts, navy yards, etc. called federal enclaves. 6. United States citizen does not mean a natural-born citizen who is an American national. State inhabitants who live in the common law venue and jurisdiction of one of the 50 Union states are not subject to the income tax laws unless they either work for the federal government, see 26 U.S.C. Clause 6331, and thus are compelled to pay a kickback for the contractual privilege received. Or they are those who produce alcohol or tobacco under Title 27, the Stamp Tax Act. The District of Columbia is referred to as a state in the income tax laws and social security laws, as well as in all other codes of the United States, to purposely leave the law open to interpretation so the courts can mold it in the interest of public policy under the colorable law of the Uniform Commercial Code. Federal law distinguishes how our government complies with the law while promulgating the fraud. Do they know the difference? You bet they do. And the following law proves it. From the Code of Civil Procedure .28 United States Code, Section 1746 Unsworn declarations under penalty of perjury. Wherever, under law of the United States, or any rule, regulation, order, or requirement made pursuant to law, any matter is required or permitted to be supported by him, as true under penalty of perjury, and dated in substantially the following form. 1. If executed without the United States, I declare, or certify, verify, or state under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. Executed on date. Signature. 2. If executed within the United States, its territories, possessions, or commonwealths, I declare, or certify, verily, or state under penalty of perjury that the foregoing is true and correct. Executed on date, signature, emphasis mine, the writers of the Code of Civil Procedure in 1. Above are referring to the common law venue and jurisdiction, that of the Republic, and in 2. Above, the statutory venue and jurisdiction of the District of Columbia, that of the democracy, not just whether one is inside or outside of the country, but whether one is legally situated inside or outside the Republic, through your ignorance in this instance will never be challenged. Please also note that when government employees and agents sign documents, they are only required to swear that the information is true, correct and not complete, as is required of those United States citizens, subjects, who submit 1040 contracts because of their so-called voluntary relationships with the district. That should incline one to inquire just who considers whom the master and whom the servant in this relationship. A word to the wise. Copyrighted at Common Law, Rev. February 27, 1998. Bob Jungles reprinted with permission.